a lot of attendees who are registered to attend, and therefore we're going to keep everybody in listen-only mode so that we don't get a lot of background noise. We will try to conserve everybody's time and move through the slides fairly quickly. We're going to hold off on questions because we know that lots of people have a lot of concerns. There are certainly a lot of folks who have already submitted questions, and we thank you for those. Where possible, we have tried to weave in answers to these questions through the presentation, but I'll also share with you a little bit later on how we can go through and ask more questions that will be answered at a later session. So hopefully at this point everybody is able to see my screen. We are going to be talking about California home care before Assembly Bill 241 and beyond. What is it and what does it mean? First of all, I would like to go ahead and introduce myself. Again, my name is Kirsten Gould. I'm the VP of Human Resources for Live Home. I have had the pleasure of working in the home care industry for over 10 years, and I have additional experience prior to this point working in the senior health care industry. I have a master's degree in HR design from Claremont Graduate University, and I've been a certified senior professional in human resources with a specific California designation since 2001. It is important for me to note that today's presentation has been prepared with care, but I need to let you know that the material in the presentation is provided for informational purposes only, and it's based upon our research and understanding of this law at the time of publication of this webinar. We have taken care to prepare the information accurately, but all attendees are strongly encouraged to contact their counsel to discuss particular circumstances. Neither Live Home nor its representatives are able to give legal advice. So let's just dive right into our presentation. Obviously, we're here to talk about AB number 241. Governor Brown signed this law on September 26, 2013. And on its face, the law is actually fairly limited. What it does is it creates the right to overtime pay for quote-unquote domestic work employees who are defined as any individual who performs domestic work such as care for a household or care for an individual in a household, and it includes live-in domestic work employees as well as personal attendants. Those of you who are in the home care industry, along with me, we're all very aware of the definition of personal attendant and this term as it's been used relative to our California wage orders in the past. AB 241 requires that these employees be paid time and a half for all hours worked over 9 in a day and over 45 in a week. Important to note that there is not an obligation to pay double time under AB 241. So the only type of overtime pay that is required by this bill is going to be time and a half, the regular rate of pay. I want to just take a moment and recognize that based upon the registration figures for this webinar, we understand that there is a diverse selection of attendees on this call. I know that there are folks who are within the home care industry, outside the home care industry, fiduciaries, individuals who may be securing care for their folks. So we are trying to keep this at a fairly broad level so that everyone will come away with a good, solid understanding of the bill. We also recognize that it may be a refresher for some individuals. You will see throughout this presentation my little red flag icon. I've included this because I think it's important for people to pay attention to specific content in the webinar that may impact them specifically. There may be some nuances to the law or things we should bear in mind for future developments. So whenever you see the red flag icon, I'll spend a little bit of time talking about why I think this is critical for us. It is important to know that before this bill was passed into law and signed by the governor back in September, there were a number of versions that went through the committees. And earlier versions of this bill actually did include a double time requirement, and there was also an obligation to provide domestic workers meal and rest breaks. Though this is not included in the final version of the bill that was signed, I think it's very important that we understand that because this was already contemplated by the bill sponsors, they or others may seek to reintroduce these provisions in the future. So that's our red flag for that point. There are some exceptions that were drafted into the bill language for individuals who will not be subject to the overtime requirements of the law. Specifically, they are individuals who are performing domestic work services through IHSS, which is the In-Home Supportive Services Program run by the state. Any first-degree relative of a domestic work employer, for example, a son or a daughter, a parent, a sibling of the individual who requires the care. And there are also provisions for child care workers, but that's beyond the scope of our presentation today. Additionally, you should know that AB 241 contains a sunset clause, and that means it's set to expire on January 1st, 2017. Of course, what we understand is that this date may be extended through any future legislative action that may occur. So what does AB 241 specifically change? Well, many of us who have been in the home care industry are, again, familiar with the phrase personal attendant, and we employ individuals who are personal attendants subject to Wage Order 15. Over the years, in certain cases, we've been able to take advantage of the overtime exemption that has been available to us under this wage order. We also know as employers in this industry that the personal attendant criteria were not fully locked down by the rule makers and the lawmakers, oftentimes subject to interpretation, and were, for many of us, very problematic to have to comply with. Regardless of this, it is important to note that AB 241 removes the overtime exemption from California Wage Order 15, but it does not change the meal and rest period exemptions. So it's specifically changing provisions of Wage Order 15 versus any larger sections of California state law. What does this mean for all of us on the call today? It means that starting January 1st, 2014, domestic workers will be entitled to receive overtime pay at 1.5 times their regular rate for hours worked over 9 in a work day or 45 hours in a work week. I should say, and 45 hours in a work week. Important to note, and in response to some questions that were sent to us in advance of this presentation, this law does apply to domestic workers who are hired privately by a household, as well as those who are employed by a third-party employer, such as a home care agency. So if you are privately employing a domestic worker in your home, you are subject to these pay requirements. In addition to the provisions of AB 241, I think it's critical for us to pay attention to the fact that there are a few other changes happening in the California and federal landscape that are going to make things somewhat challenging for us when providing care for the elderly. You may be familiar with AB 10, which passed earlier this year. And AB 10 was the bill that required changes to and increases to California minimum wage starting with July 1st of 2014. So we need to recognize that California minimum wage is currently $8 per hour and will remain so until July 1st of 2014, when minimum wage in the state will increase to $9 per hour. Just a year and a half after that, on January 1st, 2016, minimum wage in the state will increase to $10 per hour. The passage of Assembly Bill 10 will thus increase California minimum wage by 25% by the time we hit 2016, which is really an unprecedented wage hike. And initially, many of us in the home care industry thought, well, to hire, to recruit, retain qualified, experienced caregivers, we're paying well above minimum wage at this point. So maybe this won't have a tremendous impact. But these changes to the minimum wage requirements, coupled with the overtime clause of AB 241, will really make it challenging for us as employers to change rates of pay to help offset some of the increased costs of the overtime. We just won't have as much flexibility because the floor on the minimum wage is going to be increasing during the next few years. It's also important that we recognize that the Department of Labor has changed its regulations regarding domestic services, and these changes are going to take place on January 1st, 2015. So the federal level is changing as well. As of January 1st, 2015, the companion exemption offered to us and available to us through DOL regs will no longer be applicable for third-party employers. And at that time, outside of the state of California, overtime pay is going to be required for all hours after 40 in a week. Now, I've got a red flag here because though this is a federal change, it is going to impact California as well, and we will see what that impact is in a future slide in the presentation. I also want to note here that though the DOL regulation change really removes the exemption only for third-party employers, the regulations will also significantly narrow the scope of the work that an employee can perform in order to be eligible for the companion exemption. So that means that private employers, private households that employ domestic workers, individually, will have a harder time making use of the exemption, although it's not specifically been removed for them as a result of this change. So what I'd like to do is take us through a practical example that will help us understand what the changes to pay will look like for caregivers who are subject to these requirements. So I'm going to use a fairly conservative example here. This is Christy Caregiver, and she works for Mr. Smith, who's an elderly gentleman who resides in California. Lucky for Mr. Smith, he's got an extended family who can help out with his care needs. So he only needs Christy to work with him from 7 a.m. to 7 p.m. Monday through Friday while his family members are at work. In our example, again, a conservative example, Christy earns minimum wage for her 12-hour shifts. So what does Christy's paycheck look like right now? At this time, we know the California minimum wage is $8 per hour, and because of the overtime exemption available to us under Wage Order 15, Christy is exempt from overtime pay. So under this example, she's earning $96 for each of her 12-hour shifts for a weekly total of $480. Let's move forward just a few short months from now, January 1st, 2014. AB 241 is now effective, and let's see what this means for Christy's pay. Minimum wage is still $8 per hour, but now Christy is entitled to overtime pay for any hours she works over 9 in a day or 45 in a work week. So in our example, with 12-hour shifts, she's going to be entitled to 3 hours of overtime pay per day. Based upon this information, Christy is now going to earn $108 per each 12-hour shift for a weekly total of $540. $108 per day times 5 days is $540. Now, some of you out there with calculators may be concerned or confused about this calculation because you might say to yourself, well, she's subject to weekly overtime. She's worked over 45 hours starting at some point on Thursday, so why is she not getting weekly overtime for those additional hours? What's important to note in California, in order to avoid pyramiding overtime payments, is that only regular hours worked count toward the weekly overtime requirement. Christy is working 9 regular non-overtime hours per day. So she's not going to hit the weekly overtime requirement during this shift or during this scenario. Moving forward to July 1st of 2014, the change is that minimum wage has now been increased to $9 per hour. So Christy is going to enjoy this increase in pay and additionally continue to be eligible for overtime pay for hours worked beyond 9 in a day and 45 in a work week. Now, Christy will be earning $121.50 for each 12-hour shift for a weekly total of $607.50. Everything kind of changes on January 1st, 2015, and it certainly gets a little bit more complicated for those of us who are following these laws. Minimum wage is still $9 an hour, as we just discussed, but Christy is now entitled to overtime pay for hours over 9 in a day as before, but 40 in a week. The reason for this is that the federal law has now changed as of January 1st, 2015, requiring overtime pay for personal attendants and companions over 40 hours in a work week. We understand as employers, when there is a discrepancy between state and federal law, the law that imparts the more stringent requirement, which means the one that is more favorable to the employee, must be followed. So no longer may we pay overtime over 45 hours in a week. We must pay overtime for all hours worked over 40 in a week, and additionally the daily standard of over 9 in a day. So taking this into consideration, Christy is going to continue to earn $121.50 for each 12-hour shift, Monday through Thursday. Then Friday, because of the lowering of the threshold for the weekly overtime requirement, she will be entitled to a greater amount of pay, which is $144 for that Friday. So effective January 1st of 2015, she'll be earning a weekly wage of $630. The farthest out in our landscape that we're going to go in this webinar is January 1st of 2016, where minimum wage will now be $10 per hour as required by Assembly Bill 10. Christy is still entitled to overtime pay for all hours worked over 9 in a day and 40 in a work week. She will earn $135 for each 12-hour shift, Monday through Thursday, and $160 for Friday, for a weekly total of $700. What does this mean? None of us on this call feels that we should deny overtime pay to our experienced and qualified caregivers. I think we all feel strongly the need to do this. However, increased pay, as we all know, creates increased cost to our clients, to their responsible parties, to their payors, etc. So if you just look at the grid that collapses down the examples that I've provided to you, you can see that this represents an increase in pay of about 46% that will ultimately be passed along to the consumer in some form in just 3 short years. Now, this is just pure wages, so it's important for people to know this is the obligation that we are required to pay in our conservative example to Christy Caregiver. This does not represent any markup for taxes, entitlement programs, benefits where they may be available, and certainly we all know in 2015 the Affordable Care Act is going to require that benefits be provided to certain classifications of employees where they may not have been before. This also doesn't represent costs for workers' comp, et cetera, that may be included and necessary to include by agencies to provide home care to its clients. We've got red flags flying all over this slide, and the reason for that is that we have had a number of questions, numerous conversations with others in our industry and legal professionals around the treatment of live-in, or what are effectively 24-hour shifts, but what we in the industry traditionally call live-in shifts. So what is important to note, and I can't say this strongly enough, is that prior law really never contemplated 24-hour shifts. They never provided home care agencies or others in this industry with great guidelines to follow relative to the payment of these types of shifts. And in many cases, agencies, rightly so, paid their employees on a shift rate basis, a flat rate for these live-in shifts, no problem, for 24 hours a day. It's important to know for all of the folks on this call that there is not any exemption that exists or any difference in the treatment of live-in shifts contemplated by AB 241. We also know that per visit or flat rate payment structures are problematic under this law and just under other laws. These per visit rates are starting to come under attack by many attorneys and plaintiffs' attorneys. So we need to be cautious when we talk about how we are going to respond to the need for providing care and paying for care under these scenarios. So effectively, the most conservative approach and what we would believe that the law states is that we need to pay caregivers appropriately for every hour of work. If you look at that on a 24-hour shift basis, that means that these employees would be paid their regular rate of pay for 9 hours, and then for the remaining 15 hours of that 24-hour shift, it is conceivable that they would be paid overtime for those hours. The cost, obviously, is extraordinary. It's monumental and certainly not something that can necessarily be passed along in most cases to the consumer. So we look to existing case law in other industries. Those of us in the home care industry have had that available to us. Case law around emergency workers and other folks who are required to be on premises for 24-hour shifts. And we understand that in certain circumstances, a deduction of up to 8 hours of sleeping time may be taken to reduce the pay requirement for that 24-hour shift by that amount of sleeping time. The red flag flying here is that we need to know that at least 5 hours of that sleeping time that's going to be exempted cannot be interrupted for any reason. So you have to be able to provide a minimum of 5 hours of uninterrupted sleep time in order to make use of that 8-hour sleeping time exemption. If that caregiver in the home is interrupted, and the law says interrupted, the case law uses the word interrupted, it does not say called to work or required to perform domestic service activities, it merely says interrupted. So if they are interrupted during that minimum of 5 hours of sleeping time, then the entire time becomes compensable. You cannot take the 8-hour sleep time deduction if that time has been interrupted. So what we know about this is that it is difficult to monitor sleeping time. It's going to be challenging to, ensure that this time is taken. So there is some risk associated with this. But where agencies and employers want to take that risk, this could be a viable option. You want to talk to your counsel about drafting a sleep time agreement or creating some sort of document that will prove that you do have an agreement with your employee, and you want to make sure that that's lock solid in the state of California. You also want to monitor the sleep time moving forward and have a mechanism for your caregiver to report whether or not they were interrupted. Finally, there is a way to reduce live-in shift pay by taking meal and lodging credits, which are representative of, a handful of dollars per day. This is outlined in the California Wage Order 15. Meal and lodging credits will not reduce the cost of care significantly, and you do have to make sure that certain conditions are met, but this may be a way for you to further reduce the cost of pay, which will then help you reduce the cost of care to your client or to your family member. But I would urge you to seek counsel on this particular issue. Okay, so let's move on from live-in shifts, and I think we'll probably see a lot more conversation around live-in shifts in our industry moving forward. But let's talk about what the options are. As those of us in the home care industry who are third-party employers, we really only have 3 options available to us. These can be used independently, they can be used, together. They're not necessarily mutually exclusive, but they're not totally attractive options. But really what we have are the option to pass on the overtime cost in whole or in part to the consumer. Obviously the red flag here is just how much of this overtime cost we can actually pass along, yet still keep care affordable, not lose our clients to other care arrangements or to the unfortunate thought of premature institutionalization. So big red flag flying there. A second option is to reduce or somehow limit the hours that our caregivers work in order to try to avoid overtime liability, which of course is going to be problematic because we know that most caregivers in our industry want to work as many hours as they possibly can. They're supporting families, they're supporting children and their own dependent adults in the family, and they're trying to keep their hours. So it will become a challenge to recruit and retain qualified, experienced caregivers insofar as we feel that we need to try to limit their hours worked to avoid the overtime exposure. So it's a challenge. We will be obligated to, and certainly should be starting right now, all of our efforts to hire more qualified caregivers who can fill in the increased shifts that will naturally occur as the care plans change to try to avoid overtime. So recruitment efforts should be underway by all of us, and we're really going to have to redouble efforts in that area to make sure that we've got enough staff on board to fill in the gaps. Finally, the option is available to employers to attempt to restructure their compensation and pay practices to try to lower the cost of overtime. In earlier slides, I talked about the minimum wage increasing. Obviously, we can't reduce pay rates below what current minimum wage is. We also need to be very cautious as to how we restructure compensation because we know that legal liability is increased if we attempt to make changes to rates of pay that appear that we are attempting to avoid overtime payments to our employees. So just be cautious if you are making wholesale changes to your compensation for your caregivers or for any employee actually. You just want to do that in a thoughtful way. You want to have your attorney involved to make sure you avoid legal pitfalls. And you want to make sure that the communication process with your employees is open and that you give them notice around some of these changes. What are the options for consumers? Our older adults who are hiring their own care, adult children who are hiring care for their family members, fiduciaries, etc. These are options available to them that have always been available, but they really want to take some time to reconsider in light of these overtime changes under AB 241. The 3 that we're highlighting here today are obviously the ability of folks to hire privately so that they hire their own domestic workers to work within their household, independent contractors or those who are referred to them through a registry model type organization, and home care agencies, which I have focused on to a certain degree since that's the industry that I am in currently. Pros and cons around these models. I think many of us in the home care industry are aware of these. We try to educate our clients around the pros and cons of these different models. Hiring privately, obviously, I think one of the largest positives around this is that it may be one of the more affordable options available to consumers at this point. Private pay, you're worried about the wages, you're worried about, payroll taxes, some other insurance things, but you may still find a more favorable pay structure and wage structure, billing structure, if you will, than other scenarios. What we know are cons to this situation, however, is that the client or the family member thus becomes the employer. Many of us are not equipped to take on the burdens and the responsibilities of becoming an employer. We're looking at not only the appropriate payment of wages, the timely payment of payroll taxes, workers' compensation insurance, other liability insurance, etc. Those can be a significant burden to any household. Additionally, the client or the family has to perform all supervision, training, as well as address any performance or behavioral concerns with that employee. They don't necessarily have the support of somebody else helping them with those issues. Furthermore, when they're working with one individual, if that person calls off sick, if they need to take a vacation, there's a family emergency, any of those types of issues, the client or the family members are then required to have to find fill-in care for those gaps in coverage. The registry model, registries operate differently. You have to kind of, parse through what type of model the registry is operating under. In most cases, registries operate like a matchmaker. So they will connect seniors or the loved ones of seniors with screened and qualified candidates who they can then hire privately, and they may also be able to provide replacements to those caregivers and or respite care. They are, in most cases, not going to be considered the employer. They may 1099 the employees. We just need to make sure that you understand what the true employment relationship is. And that's one of the cons here. Additionally, there will be a one-time or possibly an ongoing fee for the placement of that caregiver or those caregivers through the registry. In many cases, the client, him or herself, or the responsible party is going to be responsible for paying the caregiver appropriately. And if there is an independent contractor relationship that is established, those types of working relationships are always under fire by the IRS. They are subject to audit. They are subject to challenge. And if an employment relationship is deemed to exist where one wasn't contemplated earlier, the client could be responsible for those responsibilities and have to make good on back pay, back insurance, things of that nature. So you really want to clarify what the relationship is if you're working with a registry. Home care agencies. I'm not partial necessarily based upon my business, but certainly we know what services we do provide, and fellow individuals in the industry on this call can certainly support that we are here to try to remove some of those burdens of employment and the employment relationship from our clients and their loved ones. What some of the positives are in working with a home care agency is that we provide qualified, background-checked candidates, fully screened individuals who are capable of meeting the elder's needs and fulfilling their plan of care. Caregivers are employees of the agencies, and therefore the burdens of the employer relationship do fall on the agency. Here I've indicated verify, and the reason for that is that I think particularly when times are changing, all of us as educated consumers need to ask pointed, direct questions to ensure that our understanding of the relationship is accurate. So don't just trust, as Ronald Reagan said, but verify. So make sure that the burden of employment does fall squarely on that home care agency you may be working with. Obviously, too, you want to make sure that they are paying wages and taxes and providing applicable workers' comp liability and crime insurance for its employees. I say verify here because, again, not every home care agency is necessarily hip to the changes in law. There are smaller agencies out there who may be naively unaware of changes to pay practices, and out of the goodness of their hearts, certainly they continue to provide caregivers, but they weren't aware that pay practices have changed. So you as educated consumers can ask the questions to make sure that they are paying wages appropriately and that none of the liability for improperly calculated wage payments or denial of overtime payments will fall back on the consumer, whether that's the client, the payor, or whomever is arranging for care for these individuals. So I say verify again because we need to be sure that that is going to be handled appropriately. Definitely check out any written agreements you have with your agencies to make sure that you know what is being offered to you. Additionally, ongoing supervision and retraining by agency personnel may be available as needed. You want to verify that that is indeed part of the package, that supervision of the caregivers is going to be ongoing or at least available. So ask those questions if you are a payor or if you're securing care for your client or a loved one. Additionally, we have, sort of the law of large numbers on our side, which means that we do recruit on a consistent basis to find qualified caregivers who can work within our industry. So we tend to have a greater number of qualified care staff available who can be called on, a moment's notice or with short notice to be able to provide short-term coverage or respite care as the client's individual needs change. So, home care agencies are really built on that model to have, a qualified pool of talent who could be deployed and sent out as needed. Obviously, you've seen the slides that show what the increased pay will drive in terms of increased costs. On an agency-by-agency basis, that's going to be an operational decision that they make, what those costs are going to look like for the consumer. So all I can say is that, one of the disadvantages to home care may be that it is more costly. You need to weigh the cost versus the benefits that I've provided to you. And additionally, we see sometimes that there can be disagreement in the employment policies and practices. Clients sometimes can be a little bit more lax or maybe more restrictive than the agency is. So we just have to maintain an open dialogue with our clients and our consumers about what is and is not acceptable performance and behavior about our employees so that we can work together for resolutions on those issues. I am looking at a few of the questions. I'm just going to take a quick break here for a moment and just let you know that some of the questions that are popping through, I think I've sort of addressed some of them already, but one in particular, it says, do these new rules apply to staff in an RCFE? You need to be very cautious around caregivers who provide care in facilities. Under certain circumstances, they are subject to a different wage order, Wage Order 5, which is not part of our discussion today. Under Wage Order 5, there are different overtime entitlements that are required, so you just need to look at that wage order and see what that means for caregivers who are performing services outside of the private residence of the elder who needs the service. How does AB 241 impact existing collective bargaining agreements? This is a fantastic question. I am not qualified to discuss that question, and I will say to you, happily in my career, I have not worked with labor unions. I intend to keep it that way for as long as I am able. I would certainly go back to the collective bargaining agreement. I would look at it and I would seek counsel around what this bill may mean to the changes that may need to occur to those CBAs. Excellent question. So as we kind of wrap up here, I'm at about 40 minutes, and this is really the amount of time that we wanted to try to take since everybody is very busy. We just wanted to talk through sort of, the soft issues, some of the soft issues and unintended consequences of the actions of this bill being signed. Certainly, we've talked about this a little bit, but we need to recognize that caregiver satisfaction may be impacted because we justifiably may have to change schedules so that we can manage overtime costs for our clients and for others for whom we provide care. We may have to, deploy people in shifts that are less desirable, and this could create a challenge for us in retaining our loyal and hardworking staff that we've worked with for many years. So this is a concern, particularly for home care agencies. We understand that we are going to face increased recruitment costs because we have to ramp up to meet the needs for these shifts that may go uncovered due to the change in scheduling. So we really need to get more folks identified. We need to engage with more experienced caregivers, and all of that comes with the cost of screening, background checking, time and effort, etc. We have taken calls, and I'm sure many of you have been in this position as well, taking calls from adult children of parents who are crying on the phone with us over the changes, who are concerned that maybe they won't be able to provide care or pay for care for their family member any longer, and that they may be forced into a position of having to place them in in some sort of facility and remove them from their homes, and this comes at great personal and emotional cost to people. It comes at, it's certainly an emotional issue for us in this organization, for other home care agencies who are trying to create the most positive solutions possible. This may just be, an unfortunate outcropping of the changes in the law. Obviously, impact to continuity of care may occur where clients have enjoyed having one caregiver live in 24 hours a day, 5, 6, 7 days a week. If that becomes too costly an option for our clients, we need to look at introducing additional caregivers into the mix. And that means folks are, moving through the household at different hours of the day and night. And this can really, this can be a disturbing concept for people. So the continuity of care issues cannot be discarded. We need to really look at what is going to be the best situation for each of our clients as we are challenged to make these changes. So I'm looking at a couple other questions here, and I just want to address them, although, again, we're going to have another structured way to get more questions. Challenges to restructuring hourly rates. Could the employer pay a certain rate per hour for the first 12 hours, a lower rate of pay for the next 12 hours, taking into account, obviously, the minimum wage, but paying a lower rate for successive hours? Again, I am not an attorney, and I don't want you to construe this as legal advice, but I think, some of us have been on calls with attorneys, and this is a payment structure that could be definitely challenged as a way that the employer is trying to avoid overtime liability by changing the pay structure within shifts. So I'm not saying that that's patently illegal or disallowed by this law, but that is something I would really, really encourage you to get guidance from a qualified attorney around wage and hour practice, because my sense from what I've seen is that could be a bad practice. Do these overtime rules apply to a caregiver who works for 2 different clients through the agency? May work, say, 10 hours for one client, but 5 hours for another client, so it's a multiple client issue. What you need to understand is that overtime pay is applied to the employee who is working it, regardless of what that work scenario is. So though the different clients are involved, those are not different employers if a home care agency is involved. That is a single employment relationship, and those hours worked for different clients must be looked at in the aggregate, whether on a daily basis or a weekly basis, to pay overtime as required under the new laws. Is there a way to listen to the webinar recording after it's completed? Another good question. We will be making this presentation available to folks via the website. Our Director of Marketing, Colby Rivetto, has been recording the session and was instrumental in putting together today's session, so I really want to thank him. As well, he put together the website technology so that you can continue to ask your questions as you think of them after today's session and in advance of our next session. So discussing questions, again, the platform for you to submit your individual questions is to go to the LiveHome website at livehome.com/AB241. You can input your questions there, and then we will have a follow-up webinar scheduled on December 4th, 2013 to attempt to answer as many questions as possible, maybe do a revisiting of this presentation in part, and obviously give you any additional information that we may become aware of that happens between now and then. And that is going to be at 10 o'clock on December 4th, 2013. If you are still looking at my screen, you can see the section of the LiveHome website where you can submit your name, email address, and any feedback, follow-up questions or comments, and submit that to us, and we will, again, do our best to answer those in our follow-up session. I want to thank everybody for their time and attendance today. It's been a pleasure to have the opportunity to talk with so many individuals through this session, and I look forward to speaking with you and others again on December 4th. Please feel free to go to our website. We hope to see you register and look forward to all of your questions. Thank you very much and have a terrific day.